Hi and welcome. This is going to be Protecting the Dream, IP and Legal Issues. My name is Victoria Burke. I'm an intellectual property attorney licensed in California and the District of Columbia, and I specialize in trademarks, copyrights, and fashion law. And I'm going to help you today kind of not put the cart before the horse. A lot of times, a lot of creative people, artists and designers come up with great ideas, and then they want to share them with the world as soon as they can, and then they get very upset when all of a sudden they lose their legal rights to them, or they don't understand, why did I invest all of this money only to lose out? And so what we're going to do is go over step by step some things you need to consider before you actually go out and go forward with it. Okay, first of all, your trademark. Everyone comes up with a great name for a business, and they're like, oh, this is, you know what, I had this dream, I'm going to name my business this name, and it's perfect. And they start building on that. They get a designer, they start finding like, oh, this is great, what can I use this for? And they develop around that. But that is your trademark. And that is your brand. And you want to make sure that is not somebody else's brand, because they will sue you. Because of trademark, if you do not enforce it, you will lose your trademark. So therefore, they will come after you. And you want to make sure you don't have to put in hundreds of thousands of dollars for something that could have been easily prevented. So you think, how can I prevent being sued? Well, one way you can go about it is consult a lawyer who will tell you that what you want to do is, first of all, do a search. A lawyer will do a search for you, and they'll see if this actually is taken, your trademark that you like. And after they do a search, they'll prepare an application for you. Now, with trademark, you don't actually have to use it anymore first before filing for registration. Right now, you can actually just have the intent to use it, but you must form the intent to use before you actually file the application. Otherwise, you can lose it if you're opposed, if it shows that you actually do not have the intent at the time to use it. And what is intent? Like, how do I show intent? It's objective standard, and what you want to do is create a record. With anything you do for intellectual property, create a record. If you have interest in this, you can do like trademark search, Google searches. You want to document it. Log every time you do something. Log every time you put money into business development. And then you want to go forward with your application or contact an attorney at that point. And you want to make sure that that's something that you handle ahead of time. Also, you'll hear a lot of times in Hollywood, how come I submitted my screenplay and all of a sudden the studio came out with the exact same movie as mine? They stole my idea. Well, technically, ideas are not copyrightable. And that is something people do not understand. Facts aren't copyrightable, ideas. And they're like, but it's just exactly the same thing as mine. Perhaps the studio read it, perhaps they didn't. In order to show copyright issues, you have to show they had access, and you have to also show similarity. Now, one way they can say, like, well, we never received it. You said you sent us the screenplay. We have no proof of that. Where is that? Show us the proof. One way to do it is using the U.S. postal system, because you have a mailbox rule by law, which will say that they actually did receive it. It's kind of presumed. And if you do not use the postal system, you must keep your records to show that they had access. That's the number one thing. But unless with a screenplay or script that they copied it word for word or used your actual characters or exact plot, it is very hard to win anything, because they can change very little and actually is a new creation. And another thing, with copyright, you cannot do something in bad faith. Does anyone remember those Hope pictures with Obama that Shepard Fairey did? Did you know that Shepard Fairey got in a lot of trouble for creating those posters? Okay, one of the reasons he was in trouble is that he took a picture by an AP photographer, and he thought, this is a great picture, let me transform it into something different, and it became so iconic. However, because someone else had owned the copyright to that picture, he was in big trouble. Now, I would say, I think it could have been argued in court that he transformed it in such a way that it might not have had copyright protection at that point. However, there is one big issue with that, there was bad faith that was considered because he had the name removed and he understood this was someone else's picture. It wasn't like he found it on the internet and it's like, oh, I wonder if this is stock photography I can use. He didn't try to license it, and because there's bad faith, I think they made a settlement ultimately in licensing. And a lot of times you'll see settlements will happen in licensing, but licensing fees are huge. Like if you decide to make a video in order to describe what your product is, and you're like, gosh, I want to really use this song by this band, and you're like, I'll just put it in the background because it really expresses everything that stands for my company, and it'll be great, until they find out you're using it. And then they'll be like, well, you're going to have to take it down. And you're like, well, let's work something out. And they're going to say to you, that's great. Here's a licensing contract. And you're going to be like, that is a lot of money for just one song. And you're going to have to realize you're going to have to change your whole theme, take it down. They may still decide to sue you, and you probably will not want to license it with them because it'll be prohibitively expensive. Had you checked that out beforehand and tried to work something out, then you don't have to look like a fool taking down your stuff and saying, you know what, my bad, I put up something I shouldn't have. And that makes people think maybe you weren't ready for business. You don't look professional when you have to take something down, when you have to apologize. It just kind of, who wants to do business with that person? And that's something you really want to consider as well. And also for fashion designing, when someone designs a fashion, you might see like a dress go down the runway by Chanel and, oh my gosh, look, it's at Forever 21 the next day. Like, how did that happen? Well, a lot of times they will copy designs and they'll put them out there. And you'll be like, wow, that's how did they get away with it? If you're a fashion designer, like, I worked so long and hard for that design. I worked hours. I tried different kinds. And all of a sudden, I got the right one going down the runway, and now it's being sold so super cheap, it's not worth anything. Once you see the duplicate, nobody wants to buy the original. Everyone's wearing it all around. The whole point of some of the higher fashion is having a one-of-a-kind design. So the main thing you want to understand is, with copyright, you can't copyright shapes. You can't copyright like a heart or a design of a dress, because mostly fashion is built on other fashion of the past. So what can you do? Like, what is protectable? Well, what is protectable is a design pattern. If you use a design pattern on a dress, that is a great way to make sure it's kind of stamped to yours, and then you can go after them. A lot of times they end up licensing the pattern because after a while, everyone's seen the pattern, so what are you going to do? So what you'll probably do is cut a deal. You'll see there, if you Google Forever 21 online, you'll see what I'm talking about. A lot of licensing things are settled out of court because it's just, people just want to move on at that point. But how do you know if someone says like, well, this is my flower, and they said, no, wait, well, my flower is kind of similar. So they had to be substantially similar in order to show that there is some connection. Now, one thing some people don't realize is there's some little things, techniques you can use to protect your design. One is perhaps when you do a design, if you leave out like maybe a little triangle or something in like a certain piece, if they copy it and they're like, well, no, we didn't copy it, we did originally, like, oh, look, you have this little flaw that we put here, and it's a trace. You can trace it back like that. So you actually took my exact design and put it there, and you can show that they just probably used a computer, scanned it in, and that's what they did. And speaking of like 3D printing now, are you aware of the Game of Thrones phone console someone had made? Well, they got a cease and desist letter from HBO who didn't appreciate the fact that they took the design of the Game of Thrones throne for their cell phone holder. And the person that put it online, like, isn't this fantastic? Isn't this great? I came up with a throne for my phone based on my favorite show. And HBO is like, nope, we've already licensed something like that with someone else. So you might have already infringed upon somebody. Now, you really don't want to do copyright infringement, especially since they have attorney fees, and attorneys, make a lot of money. So therefore, you kind of want to avoid losing your money to some attorney. So if you actually start and look at it to say, how can I fix this before I get started? Another important point is design patents. A lot of people don't realize the difference between regular utility patents and design patents. A design patent is such for example, is a Coca-Cola bottle. You'll look at it and like, oh, that's a great design. They have it patented. So you don't say, you know what would be great if my pop, something that looks like Coke so people will be drawn in. They will go after you for that. And a design patent's actually not that expensive. So you want to invest in that ahead of time. And that is, I believe, how Apple also defeated Samsung, is they used design patent and said, you know, the way we arrange things here, that was actually, you know, and so you want to realize that there's multiple different levels you can pursue, but you want to do this beforehand. Such if you're doing a writing, you want to register as a writers guild because you want to help yourself establish proof. Even though you have like copyright protection the instant you put it down on pen, you want to make sure you can say, you know what, I did pay the money to have this copied. Or if you're going to base your whole design on, let's say, for example, Burberry, they have their distinctive plaid that is actually trademarked and copyright protected. So when they see it, they can say, like, you know, that looks substantially similar to ours, and they're able to sue. And that, ladies and gentlemen, is one way to protect all your investment. Another thing I want to talk about is crowdfunding. It's really important now to understand the SEC is still evaluating what the rules would be with crowdfunding. Under the Jobs Act, there's a crowdfunding subset act, and they're still trying to figure out the rules for that, such that many times when you start up a crowdfunding project, you'll say, you know what, I'm going to give away something. It's usually something nominal. But if you start giving away something that has value, it starts to look like investment, and you don't want to mess with the SEC with investments. So if you happen to say, like, if you donate $100, we'll give you the first prototype phone, which has market value of $500. Wow, I just made $400 off a $100 investment. The SEC will want to know a lot about you then. If you're going to start doing that, they'll want disclosures about your corporate. They will have a whole bunch of stuff. I included an article that I wrote in 2012 concerning some of the risks of crowdfunding that people have not considered. Now, of course, we're springing forward. We're in 2015 now, and they still haven't come up with the proper rules yet. SEC still has not set them down yet. They think in October 2015 they will have the rules set up, and they'll be ready for 2016. But you would probably want to get a jump on it and refresh yourself before you start saying, you know, I got this great project. I did all the IP things. I'm now ready to go get my money. Where's my money? So you don't want all of a sudden the SEC said, that's great. Where's our money? Because all of a sudden they look at your investment and they're like, well, this looks like you're doing something kind of fishy here. And one of the reasons you have to look at it, they want to protect some unsophisticated people. Now, that's a legal term for someone who's not aware of how things are done in a certain business. It's not being rude saying someone's unsophisticated. It's something to protect, like, let's say a grandfather who has a retirement fund. He says, I want to put all his investment in this crowdfunding thing. Sounds great. And they lose all their money and they have no protection. So the SEC is actually looking after some other people as well. So just make sure to think ahead. Don't put the cart ahead of the horse, and you'll be very happy having protected your dream. Thank you.